This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Page 33, damages measurement. How do you assess the extent of the damages to be awarded? The courts determine how much award is necessary to put the injured party into the position that they would have been if the contract had gone ahead. And we got the case C&P Haulage in Middleton. A small business is renting some premises, a lock-up location, is renting some premises from the local council. And it's a term within their agreement that the premises will be rented for 6 months, and that any improvements or alterations that the tenant makes would be left in those premises at the end of the tenancy, at the end of the 6 month period. So if you put shelving up, or if you paint it, or if you re-electrify it, or if you install plumbing, or whatever the tenant's improvements which take place in that 6 month period, they will be left in the premises at the end of the 6 month period. And the council gave C&P Haulage, they gave them notice to quit 11 weeks before the end of the 6 month period. So C&P Haulage now sue the council, not only for breach of contract about the 6 months, but also because they had installed all these improvements and they were now not going to have the benefits of those improvements. And it cost them a lot of money to install these improvements. And the court looked at it and said, yes, but if you had left at the end of your tenancy, you would have had to leave all the improvements. So you can't claim the cost of the improvements. You can claim an element of the inability to use those improvements, but you can't claim the entire cost. So in measuring the damages, the court will look and project, if it had gone ahead, could he then have taken his improvements with him? No. And therefore he couldn't claim for that. He couldn't claim for the full cost. He could not claim for the full cost. May take account of speculative loss. To speculate is to gamble, to speculate. A different word, different use of the word speculate is to try to foresee something in the future. You speculate about what would happen if, is a speculation. I'm thinking about what might happen if I do this or if I say that. I will speculate on the revision course. I will speculate about what I think might come up in the exam. But that doesn't mean to say that I have any idea of what's going to come up in the exam. It's just not wild guesses, but it's just guesses, so don't pay great attention to it. May take account of speculative loss. Thompson and Robinson. Thompson and Robinson Gunmakers is the true title. And just while we're there, with gunmakers, I have to ask, don't I? Large pleasure, yes, large pleasure. What was the case involving large pleasure? And the girl? Lynn, Gunthing and Lynn. But we've also had other weapons as well, haven't we? We've had the flick knife case, absolutely. In fact, I made a special point today of bringing my own version of the flick knife. It's my car key, in fact. But if I push the button, the blade flicks up. All right, that's a flick knife. It's not a flick knife, it's a car key, but it's the same action. It's a flick key. Yes, a flick key. Thank you. Have we had any other weapons? I think we have. What do Bushmen in the Kalahari Desert of Africa How do they kill animals when they go hunting? What do they throw at the animal in order to kill it? It's a sort of long thing, and some guy from your country keeps winning Olympic medals in the... Yeah, the sort of javelin. It's actually a spear. And we had a case involving spears, didn't we? Yes, we did. It was spelt differently. Poussard and spears and pond. We did have that weapon there. And then we've now got another weapon here, Thompson and Robinson gun makers. This is about the sale of a car. About the sale of a Vanguard car, it's called. Again, they don't make them these days, but the model of car is called a Vanguard. And Vanguard cars, the supply of these things was rather greater than the demand. They were easily available. And we have a contract between these two, Thompson the dealer and Robinson the buyer. And Robinson says he doesn't want the car. He's ordered it, he doesn't want it. And so they sue. And Robinson's defense was that, well, what have they lost? They've not lost anything, have they? Because they are able still to sell the car that they would otherwise have sold to me. The profit is still there, and they are able to sell it. But Thompson said, yeah, but the supply of these cars is greater than the demand, and it's costing us money keeping this car in inventory ready to be sold, and it's costing us space on the forecourt where we put all the cars to show people so that if they want to drive past and say, oh, look, there's the Vanguard, let's go and buy it. So there was an additional cost. It was hard work selling these cars, and therefore they claimed for the work and the effort and the lost profits that they would otherwise have made, and they won. Even though they still had the car, I think it took them 4 months to sell another Vanguard, and therefore they'd lost profits for 4 months. But that compares with the next case down, not Anglia TV and Reed, you can look that one up for yourself, but Lazenby Garages and Wright is another car case. This time it's a BMW. And Lazenby Garages have bought this car, this BMW, for $880, and they have agreed with Wright that they will sell it to him for $1,320. But then Wright says, I don't want it. And he breached the contract. So Lazenby Garages were then able to take this car and sell it for $1,440. And then they sued Wright for their lost profit. What? Go on, say it. Did they get it? No, they didn't get it. They didn't get it. They'd not lost the profit. In fact, they made an extra profit, hadn't they? They made an additional 120. And they sold it quickly. It was only a 3-week sale between the original contract date and the new contract date. So there's no major effort in selling this BMW, and therefore they hadn't lost a profit. Now, this upsets me a little bit, this case, because I think to myself, and maybe you do, if they had sold the car to Wright, they could then have used that 1,320 to buy another one, which they could then have sold for 1,440. I think they did lose a profit. But I'm not a judge. And the judges said, no, they haven't lost a profit. Now, I don't think confusion is the wrong word. I just unable to reconcile the court statement that said they haven't lost a profit, because I think they have. But you listen to the court decision, you don't listen to me. The court may, halfway down, the fifth bullet point, the court may consider non-financial loss. How difficult is that to measure? It's all right measuring financial loss, but how do you measure non-financial loss? And the first case they did it was the case called Jarvis and Swan Tours. And we're back again with our birds, aren't we? Yeah? Go on, tell me the bird cases. All of them. The bird cases. Partridge and the other person, Crittenden. Go on. A big grey bird with a long beak that eats fish and frogs and water creatures. The ree heron too, yeah, ree heron too. Other birds. Have we had any other birds? Do we have any other birds? Did we? I can't remember any other birds. We've got one case with two birds, haven't we? We've got partridges included with bramble finches. Yeah. Okay, here we are with our Swan Tours. Jarvis is a solicitor, an advocate. I don't know what you call them here. Solicitor, are you happy with solicitor? Yeah. Jarvis is a solicitor. He's late 50s, lives alone, always has lived alone since his mother died, before which he used to live with his mum. And he doesn't have a particularly active social life. He rarely goes out. He sits at home and maybe reads a book and then goes to bed and gets up and goes to work. I think he's got a sad life. There's a sad old man with no interest in life. And he realized this and said, I'm going to take my life and I'm going to change it. I'm going to go on a holiday. I'm going to go and really enjoy myself. And he got a holiday brochure from Swan Tours, and the brochure showed this wonderful holiday resort and a super hotel with a gorgeous swimming pool, and the sun was beating down, but it wasn't a photograph, it was just an artist's view of what this hotel was going to look like when it was finished. And it recommended and advertised the fact that it would provide him with a holiday of great relaxation and pleasure. And so he booked the holiday. And when he went there, the swimming pool was full of builder's material and no water. And the hotel didn't have a roof. And in fact, the last 2 or 3 levels of the hotel had also not yet been built, but they were in progress, so when he was sleeping in the hotel, he could hear that the builders were built. He had a dreadfully stressful holiday, and he was really upset, really annoyed, because he'd booked the holiday for rest and relaxation, and in fact it was stressful. So he sued, asking for his money back on the basis of lack of amenity, lack of enjoyment, non-financial loss. And the court said, well, yeah, you have suffered. The ultimate purpose of your holiday was rest and relaxation, and you didn't have either rest nor relaxation. So they ordered that the tour company should repay the cost of the holiday. I don't know, did they do plus? Have you got it there? Oh, plus, all right, plus loss of pleasure. Some compensation for his loss of pleasure. That's if you can show the court to their satisfaction that you have lost enjoyment. The case Alexander and Rolls-Royce. Alexander owned a Rolls-Royce car. And his pleasure in having this Rolls-Royce car, his pleasure was to get in the car and drive around the town, showing his Rolls-Royce car. He got great pleasure from sitting there in this wonderful classic car. And it went in for repair, and Rolls-Royce took longer than they should have done. They maybe took a week longer than they should in servicing the car. And he was not able, therefore, to sit in his car and drive around and enjoy the envious looks of people as they saw Alexander. Oh, there's Alexander in his Rolls-Royce. So he sued Rolls-Royce for his loss of pleasure, and the court said, in 2 words, go away. They didn't actually say that. The court was rather more emphatic when they told Alexander he was not going to be given any award of compensation. And then this last couple of points, just before the very last one. If the cost of repair, if I'm in a contract and the other person breaches it, it may be that as a result of that breach, I am going to suffer what's called a lack or a loss of amenity. I'm going to lose some pleasure because they've breached the contract. But to get them to remedy or rectify that breach is out of proportion with the amount of pleasure that I have lost. All right? There's a question, and it may not now be in the exam kit, the current exam kit, I've not looked, but there used to be a question called Astrid's Wall. And I'll tell you about Astrid's Wall case, and then we'll have a look at this case in the notes, Ruxley Electronics. Astrid had just bought a new house, and in the distance from her garden, she could see the local rubbish tip, where all the town's rubbish was being piled up. So she contracted with a builder to build a wall which had to be 3 meters high, and then she wouldn't be able to see this rubbish, which I think is perfectly sensible, perfectly common sense. And the builder came along and he built the wall and finished it and then said to Astrid, there's the wall. And she looked at it and said, that's not 3 meters. That's only 2.5 meters. I wanted it 3 meters. What can she do? Well, I've got a common sense answer here, but apparently it doesn't feature in exam answers. I'll tell you that in a minute. The cost of the wall was meant to be £3,000. But because it was only 2.5 metres, the court said, well, just pay £2,500. Instead of, I'll pay therefore at £1,000 per metre. But she can still see the rubbish tip. So she gets compensation for a wall which is shorter than she hoped for and does not achieve what she anticipated. But to make the builder knock the wall down and start all over again was going to be out of proportion with the loss of amenity that Astrid was enjoying or wanted to enjoy. So the court ordered a pro rata reduction in the amount payable. Now, I don't think that's a sensible answer. But I'm not the examiner, am I? And I'm not a judge. Why did they not say, and I may be being very simplistic here, why did they not say to the builder, take the top stones off, put another ½ metre on, and then put the top stones back? Would that not have been sensible? But that never features in any exam answer, so maybe I am being too simplistic. But it's the question is based on this case, Ruxley Electronics and Forsyth. And Ruxley Electronics and Forsyth is about a swimming pool which was being built. Clearly out of proportion, but it's meant to be 25 metres long, it's meant to be 10 metres wide, and it's meant to be 2 metres deep at the deep end and 1 metre deep at the shallow end. And when the swimming pool manufacturer, when the swimming pool builder had finished, it was found to be only 1 metre 80. It was found to be only 1 metre 80, and it was not therefore as deep as was originally intended. So what's the court decision? Yeah, reduce the price by 10%. It should be 2 metres, it's only 180, that's a 10% difference. Reduce the price by 10%. Now, again, apply the same logic as in Astrid. What would be the problem with putting a layer of brick on the top for 20 centimetres and then filling it up to there. Well, to replace the thing, you've got to empty all the water out, dig the whole thing up, bring your big diggers in, dig out another 20, relay the concrete, relay all the electrics, and it's crazy. I mean, the amount of repairing that 20 centimetres is way out of proportion with the loss of amenity for Forsyth. But why not just put 20 metres of brick on the top? Well, no, because what you could do is you could backfill the brick with soil, couldn't you? And it would look nice, actually, landscaped with a bit of soil and some daffodils and maybe some birds. It would look really nice, I thought. Well, that would be my answer to it, is to extend or to raise the height of the swimming pool, raise it by 20 centimetres that way. But no, it was because it was 10% wrong, the 10% price reduction came through. The only situation that I can imagine where the court would say, dig it all up and start again, is if Forsyth had been, for instance, an Olympic swimmer and he wanted this in his garden in order that he could practice, or particularly, I mean, when you swim, you tend to swim across the top, don't you? You don't swim down at the bottom. So if he'd been an Olympic diver, and he'd needed 2 metres worth or specific depth of water, then I could understand it. If he'd been a very tall person, more than 2 metres tall, then he would have wanted at least a 2 metre depth to it. So those are the only situations, and they're a bit extreme, and exam questions don't go into it. Jeff, who is 2 metres 30 tall, has a swimming pool which is built, which is only 1 metre 20, blah, blah, blah. It doesn't do that, so that's not going to happen. But common sense would say raise the depth by building upwards, like with Astrid's wall. Just put another 0.5 metre on the top of Astrid's wall. But I'm a simple man. I don't know these things. Page 35.